Welcome to Schindhelm 365. Insights, outlooks, current perspectives from the world of business law.
Okay. We have decided to use the potential of the Schindhelm network to provide you with the information about home office regulation in Europe. Of course, many employees would like to work while traveling in Europe, also even outside Europe, but today our focus will be on Europe. On one hand, we are living in a COVID times, and technologically it is very easy to work remotely from all over the world. But on the other hand, the legal conditions make it very difficult. In particular, I'm referring to social security and tax regulations. So in today's webinar, we will tell you how to legally work remotely from Austria, Czech Republic, France, Germany, Italy, Russia, Slovakia, and Spain. And from each country, a local lawyer will speak. So the information will be definitely first-hand. I would also like to thank co-organizers of our event, the Association of the Business Service Leaders, ABSL, thanks to which our event gained many distinguished participants. I would also like to thank British-Polish Chamber of Commerce, German-Polish Chamber of Industry and Commerce, Scandinavian-Polish Chamber of Commerce, and Europa Forum for their support in promoting our event. Many thanks for you. And great thanks to somebody who is very important in case of organizing this event, Kasia Gospodarowicz, my partner from my law office, the head of our immigration department. Kasia, show yourself, because without you it will be impossible completely. Kasia, are you with us?
Yes, thank you. Good morning. Thank you for these words. It is a pleasure to gather all these people during this webinar. As I make a few words, only 1 minute, I know that you have a lot of questions as our clients and potential clients or the organization referring to home office in Europe. So that was our aim, to just gather the specialists in this area and to pass you all those information. So be please free to ask any questions, but probably Wojciech will tell about the questions.
Yeah,
so thank you.
I will tell about this. I just wanted to promote you because you took us together, all these guys from the different part of Europe. Of course, the handsome guys and very wise guys, excluding me.
You can show yourself because you are just invisible for us.
Okay. So I don't know why, but it's not a problem for me that to be covered, undercover even. Okay, but returning to our event, Kasia, thank you very much. I repeat after Kasia. Of course, you can ask our guest questions, but due to the number of the participants, which is now more than 100, please use a chat. We checked it and it is working. So if you have any question, please ask on the chat. But what is more important, if you are asking a question about specific country, please name the country. It will make it much easier for us to answer, because the lawyer from specified country will answer your question. Okay, so returning to our event, because we were organizing it in Poland, and as you know, the Polish legislation now is planning to introduce new regulation concerning remote working, because now we are operating on the regulation of labor code, which is connected only with the telework. So just permanent work from home. And the other regulation which we are using now is the COVID regulation about the remote work. But it is the let's say it's quite simple regulation. We can order homework for our employee, and our government prepared some kind of the project of completely new regulation, but my last knowledge is that it was big discussion, but huge discussion between the employer representative, trade unions, and the government. But we have Viola Bobrik from ABSL, and she is very close to all this government and legislation issues. And Viola, can you tell us what stage of the works on that regulations? Viola.
Thank you, Wojtek. Welcome, everyone. Indeed, our government worked on the new regulation almost since a year, and during the spring they published the project which is supposed to enter into force in January 2022. However, and it was, I must say that it was quite favorable for the employers and employees, the regulation, because it allowed fully remote work from home. It regulated a reimbursement of some costs on the employee side. So we had also a quite interesting regulation related to the incidental remote work, but in a moment when its politics come into light, in the moment when the Porozumienie party exited the government, the Department of Labor Law, which was placed in the Ministry of Development, was moved from the Ministry of Development back to the Ministry of Labor, and the project was frozen at that stage. So the last stage was when the project was in the interdepartment, interministry arrangements and agreements, and they agreed on some discrepancies between ministries, and they stated the ministers' opinions on the project, and now we see that it is frozen in the Ministry of Labor. Unfortunately, we also see that some voices from the government related to the project are not favorable to the solutions itself. So, in my opinion, it will not enter into force in January 2022, as was promised by the government. But what is important, we are really pushing to move forward with the works on the project and with the entry into force at least next year. But I don't want to delay this Polish part, because we had plenty webinars on the Polish solutions to the working from home. I would really like to listen you guys and see at which stage you are in your countries with the regulations, and how it is solved in your countries in respect of the working from home. Thank you.
Thank you, Viola. Thank you very much. But I want to try summarize what you tell, but I have a very bad feeling about this, like in Star Wars. So I expect that now we can say that we are in the middle of nowhere in case of remote work, because I fully agree that in case of labor law regulation and legislation, the procedure of legislation, such a regulation, it is impossible to have it on the beginning of next year. So it is not good news for the employers, but also for the employees. So in fact, not a good news at all. Thank you anyway. And we are starting our travel through Europe. So we were discussing the weather before the start of our event. So definitely we have to choose something warm, sunny, and beautiful. So we will start with Italy. Florian, the floor is yours.
Good morning. Thank you, Wojtek. Yeah, my name is Florian Bünger. Despite my kind of unusual surname, I'm actually an Italian lawyer. First of all, I would like to thank Wojtek and Katarzyna for this excellent initiative, which seems to be extraordinarily interesting, and I'm honored to be part of it. If you allow me, I start with 2 quick words on my person and the office I'm representing. I'm a partner of the Italian law office dnia Schindhelm. We are based in Bologna, a classical, I should say, medium-sized business law firm. We are 10 lawyers with 3 partners, and we are busy in basically all kinds of company law, ranging from labor law to mergers and acquisitions, and with a special focus on international aspects. And it's now 6 years that we are part of the Schindhelm Alliance, so that all of the other speakers are colleagues for a long time now. And that proves to be a very interesting and helpful collaboration, as we can see from this event. As I said, I can't hide it. I was born and raised in Germany, but it's nearly 20 years that I practice in Italy. So I'm a German and Italian lawyer. I'm part of the labor law and commercial department of a firm, and this is basically why I'm here. Having said this, my task is to give you a quick overview, and let me see if I manage to start my presentation. Oh, that should work. And my task is to give you a quick overview of what working from home office means from Italy, with a specific focus, obviously, on transnational aspects. In this context, what we have to bear in mind, I think it's, first of all, what is home office? What are the domestic rules applicable on it? What is the concept? Then which law governs the working relationship between a foreign country and an employee who is effectively working from Italy? And then, of course, implication on social security and taxation, as Wojtek actually introduced in his introductory speech. What we're not talking about is, of course, business trips, which are limited to a very short period, and they have basically no proper implications. And we're not talking about dispatching workers to for a specific purpose to a connected entity. What we are talking about is, well, as Wojtek said, the weather is nice in Italy. We have currently 22 degrees, basically. Oh. And it might happen that someone who is not Italian chooses to work from Italy because the country is nice and the weather is nice and the food is even better, or because an Italian citizen chooses to work for a foreign company, like a Polish company in this case. So there might be a number of cases in which work is organized from a different country and not from a local entity, but just because the person chooses to be there. So the first thing, what is it that when we talk about home office, what do we mean in Italy? I think we're in quite the same situation as in Poland, as I just learned, because the legal framework is rather incomplete. we're traveling on site, if I could say this way, on emergency regulations due to the COVID situation. And what is a bit lacking is a comprehensive framework, and it starts with some kind of semantic linguistic confusion, because the term home office doesn't really exist in Italian terminology in the public debate. We're talking, the general term used is smart working, but this is only part of the possible situations. Because if somebody works from home, it might be the classic telework, which basically means that the same work and the same working environment is replicated from the office to home. The circumstance has a legal framework, but it's basically never used, so I will not waste time talking about that, because it's too complicated. Nobody really bothers to replicate an office hundreds of times in the respective homes. Then there's a concept of remote working, which might come closest to what is generally meant when we're talking about home office, which means that somebody works from home with a certain degree of flexibility in where he stays, and but with basically with the same rules and working hours. And then there's smart working, which, as I said, is generally used as a term for anybody who works from home, but improperly, because the concept of smart working, which is also governed in a rudimentary way, means that there's a maximum degree of flexibility, and basically the responsibility to achieve a result is left to the employee. That's why it's called smart working. And how the hours are organized, how the workflow is organized, is left to the employee in question. And he could basically go to the beach, take his laptop, stay under the umbrella, and work from there if it pleases him. And if in the end the result is achieved, then it's fine. So this is smart working is actually the concept used for anybody who works from home, but somewhat improperly, because especially this kind of the concept of project is usually not actually implemented. Talking a bit in general of what is required in working, I will continue to use the term home office, although in quotation marks, because as I explained, smart working is not actually it's used a bit improperly. What is necessary is, of course, an agreement with between the company and the employee to change the rules of the normal contract. There's outside the real emergency situation, there is no unilateral right of the company to send a person home. And there's the obligation to provide proper equipment. That is a computer, a laptop, a suitable monitor, a smartphone, a protected internet line. And it's necessary to respect the rules on safety and health at the workplace. That means, at least on paper, the employee has the obligation to make sure that it's a safe place. Although I have to say right away, to my experience, this is never controlled. In theory, that means you're not supposed to work in the kitchen, because then something could happen to the documents and to the person, and the computer has to be put in a proper position to protect the neck and the proper posture. To make sure, at least in theory, that all this is respected, it's necessary to make an official communication to the public labor authorities. In Italy, it's called INAIL, but to my experience, usually this is not under scrutiny. Again, on the specific obligations, there's some bureaucratic steps to follow, in particular for foreign employees. You need a fiscal code, both for the employer and the employee. Without the fiscal code, the so-called codice fiscale, you are nothing in Italy. The term is a bit misleading. It doesn't mean that it's used for tax purposes. It's kind of a personal ID number, basically, which serves to identify an entity, a natural person. So whatever you do in Italy, if you have to do something official in the broadest term possible, you need the fiscal code, but that is easily obtained. It takes a couple of days, basically, a module to sign, and then that's it. It sounds more scary than it actually is. For the employee, it means if the stay in Italy goes beyond 3 months, it's necessary to obtain to register basically with the local authorities to communicate the presence, and not to obtain a proper residence, but yeah, to be registered. And then there's the obligation, as I just anticipated, to protect the employee's personal safety and the confidentiality of data, which basically means it's not possible just to say, well, you stay home, you've got your own laptop, you might have your own telecom, internet, and then it's fine. It would be best to have a virtual private network and to make sure that both the company's data, which is obviously in the genuine interest of the company, but also the personal data of the employee are protected and not kind of randomly spread over the internet. In particular, parting about smart working, which apparently continues to be the term used. There are rudimentary rules introduced with the so-called Jobs Act, which under the government of Matteo Renzi introduced a complete overhaul of basically all rules of labor law in Italy. And under this framework, it's necessary to, when amending the individual employment agreement, it's necessary at least to introduce specific rules on working hours and on the execution of the work and how the project has to be achieved. One of the problems actually is, and I can't see how this will be solved, is what to do with extra hours, because the whole concept of smart working requires a degree of flexibility, and one has to obtain a result. If the employee is quick and smart, he might do it in 3 hours a day and then go to the beach and be happy, and everybody is happy because the result was achieved. If he's slow, it takes him 12 hours. What happens with the extra hours? Because the whole concept of smart working does not entail registration of hours, because this is contrary to the idea of a project. How this can be conciliated with the recent jurisprudence of the European Court of Justice, who basically state that every single second of extra hour that goes beyond the ordinary hours has to be registered and paid, I don't know, and I can't see any activity how this should be addressed. So I'm as curious as you might be. Then we come to the labor contract. Of course, if a person works from Italy, he might even be Italian, and the company is Polish, you have to ask yourself, what kind of contract do I use? I can understand that the Polish company would be happy and to use the specific Polish standard contracts and treat the person as everybody else with the few specific rules on places of work and whatever, but basically use the standard contract. This is allowed and permitted by the European regulation, so-called Rome I, on applicable law, which says even for labor contracts that the parties are free to choose the applicable law. But the question is it wise to do so, even if it's possible? And we will see a number of reasons why maybe this is not the best idea. The first is predictability, because obviously the same regulation allows for the home country of the employee, that is in this case Italy, to apply mandatory provisions of national law. In case of labor law, this means protection of the employee. So Italian provisions may overrule a Polish contract, and of course I have no idea about Polish labor law. It might be have the high standards, but maybe just for academic exercise, I may assume that standards are very low. So that may mean that Italian rules on minimum wages, on notice period, on on holiday, on specific leave permits and whatever apply on maybe on the 13th or 14th salary or whatever. And there's obviously no list what is mandatory and what not. So you don't really know what you're running into. So you have a contract, but you never know if it's going to work or not. And I'm not even talking about terminology. A certain term used in a Polish contract might have certain implications if a Polish lawyer used them thinking about Polish law, and the same term might have to be interpreted in a different way if translated into Italian language and framework. And then we come to a specific aspect of Italian labor law. I call it the monster of Italian labor law, the collective bargaining agreements. I recently had to check the collective bargaining agreement on chemical industry, and I discovered it has 400 pages. Collective bargaining agreements in Italy basically contain all interesting rules on labor law. It's not written law, it's left to collective bargaining. They contain basically everything from working hours to special rights to wages. And since the collective bargaining agreements apply anyway because they define the minimum wage standards, you can't escape them. And I think this is another reason for which you can't really handle a foreign contract, in my opinion. And the third aspect is it's also a separate aspect, but it comes into the play because once you're talking about social security contributions, you have to know if your Polish contract, how that fits into what are the proper rules to pay social security contributions, what does it mean if you want to translate gross wages into net wages. And even that aspect has to be taken into account when choosing the proper contract format. The answer here for Italy is fairly easy. Social security contributions follow the principle of territoriality. The contributions have to be paid wherever the employee has the residence, or at least the domicile. That means if somebody works from Italy, contributions are paid in Italy, period. And there's not really a way to escape it. The only way to escape is for very short-term periods. I shouldn't say this as a lawyer, but of course, if somebody just stays a bit longer for vacation, like a month or so, maybe it's not necessary to tell anyone, and then before anything happens, the person is back to Poland. But I don't think this is a situation we're talking about. Once the situation is vaguely stable, communications have to be made to the competent authorities, the Labor Security Office, INAIL, I mentioned before, the Social Security Office, INPS, and contributions have to be paid. And so, go back on a second. Just to sum it up, in my experience and my conclusion, whenever a person works from Italy, it's the only way to handle the situation is in having an Italian labor contract. It might appear handy in the first sight to use their own proper standard contracts, but in the end, it's difficult to handle. Of course, you may hope that nothing happens and then the contract ends and you never litigate it, but this is not what contracts are about. Contracts are about certainty. And in my experience, you can't obtain certainty if you mix up different legal systems. Last but not least, taxation. It's a bit less clear than in the case of social security contributions, because Italy abides by the recommendations of the OECD rules, and which basically say taxation is made where there's stability. And the stability in a foreign country is basically obtained after half a year. That means if a person stays in Italy for more than 183 days, taxation is made in Italy. Whenever it's less than taxation would be made in Poland. And of course, it's a bit more complicated because there are bilateral agreements and tax credits and double taxation and worldwide taxation. But the bottom line is this: if it's more than half a year in Italy, you will be taxed in Italy. Just a final recommendation on this issue. The person might have, of course, very different tasks, but it's important, I think, to avoid to create not a workplace, but a permanent establishment. It's particularly if this person has commercial tasks. If this person generates turnover, that means it's Italian turnover for the Polish company, and then you have to file Italian tax declarations, and you will have to litigate between Poland and Italy where to pay taxes, because of course both authorities want to have as much money as possible, and tax credits help you up to a certain point, and only once the situation is cleared between the two countries. So it would be wise to avoid to give that person the power to sign contracts. If it's a technician and an IT expert, of course, the problem is non-existent, but if it's a commercial person who should kind of cure the Italian market, it's advisable to pay attention that this person has no power to sign contracts, just to contact clients, and and then leave the power to decide to somebody else who stays in Poland. So that is a pretty safe way to avoid being taxed in Italy. So the conclusion is working in home office in Italy might sound complicated, but it's in the end it's not really so complicated. It's kind of typically Italian. For certain aspects there are few rules, other aspects there are too many rules, and more often than not the rules badly fit together. But that, as I said, is typically Italian. Rules are complicated. Reality is less complicated. Italians are famous for kind of finding ways around strange rules. In the end, things work. There's a certain degree of mental flexibility which helps to obtain the result, let's say, despite the rules which might not be so clear. All you need, I dare say, is a lawyer who helps you structure your project, and a consulente del lavoro, which is kind of a tax advisor specialized in all these labor-related aspects. Lucky enough for you, if you want to come to Italy, Schindhelm can provide you with both. Thank you very much for your attention.
Thank you, Florian. Thank you very much. It was very interesting, and I was observing the chat. So a lot of people is planning coming to Italy and working from there. So you will be very busy answering the question. What I can add that in case of the question, is there any safe period for PL employees to work from Italy? There is no such a rule, because we have the same regulation in the whole European Union. If you are working from one country, you belong to social security in that country. That's the main rule. There are some exemptions connected with the A1 and connected with the business travels, etc. Of course, we are not today. We won't dig in details, but there is definitely there is no safe safe period. What we can say, and what in fact Florian said, that of course, if you are working 1-2 weeks, probably nothing will happen. But you have to be prepared that in case of any accident, any problem, any health problem, it can create for the employer but also for the employee huge problems. We have such cases. We had such cases. So we have to be very, very careful. But for the rest of Italian part, Florian will answer. And we are traveling very fast. So now we are traveling from sunny Italy to very interesting part of Europe, and the biggest one, Russia. Thomas,
yes.
Tell something about yourself, about your office, and definitely about working remotely from Russia.
Yes, good morning, everybody. It was actually very interesting to listen to Florian, the news from Italy, because I live in Moscow. since more than 20 years, but I also spend a lot of time in Italy working remotely. So I think I need, Florian, I need your advice on Italian law next time I'm coming to Italy. Well, yes, I'm a German attorney at law. I've been working in Russia almost 25 years. We are a full-service law firm and advising mainly incoming business. That means German companies, German-speaking companies, because I'm German, but also European businesses. We also have actually some Polish clients doing business in Russia. Our clients are distributing products here in Russia or also producing. And we also have a couple of clients in the IT industry. And actually remote work is very popular in the IT sector, I would say. And we also have a lot of very good specialists in the sphere of IT in Russia. So a lot of foreign IT companies run their research and development centers here. And we've actually been advising in one of those projects this week. So it's really interesting. Yeah, let me get started. What I have to say is that in Russia, the legislation works pretty quickly. Now I have to check with Katharina how I can switch the slides. Katarzyna, can we pass to the second slide?
You can do it by yourself, but if not, I will definitely do it for you.
Okay.
Please try. Could you try?
Well,
it's not working.
It's working. I did it.
Now it works.
Okay.
Okay. I hope it works. Otherwise, I will let you know. Good. Here it's a little bit different than in Italy because the legislation works pretty fast, and we already have a new law on remote work in place since 1st January 2021. So, of course, the reason for the changes was the pandemic, and the Russian Parliament did a pretty good job, I would say. They worked very quickly because there was really a huge need for making amendments, because the law that was in place was not sufficient for the situation that actually occurred. The new rules, now they amend the labor code, which is a pretty big code regulating all the labor relationships here in Russia. And differently from Italy, the Russian labor code, the Russian labor law applies to all employees working in Russia. So also if you send somebody from Poland or from Germany, if he starts to work here in Russia, Russian labor law applies. Anyway, the new law is pretty comprehensive. The overall approach of the law was to make remote work more flexible, but also at the same time secure for the employees. The main issue was that, of course, you had also before long distance working here, and the simple form of remote work, but we have seen that that is not enough for the future. And what is a main principle now, that we don't have only permanent remote work, but we have different types. We have permanent and continuous and periodical remote work, which can also be combined. So there's a huge flexibility. What you always, of course, need is you need supplemental agreements to your labor contracts and other things. I will not get so much into the details because I want to talk about two topics that are, I think, more important for you than all the details. Anyway, I want to say is that, of course, there was a big discussion here. People were working from home, using their own electricity, their own computers, their own telephones. And there were disputes who bears the costs, and the new law clearly states that, first of all, the employer has to bear the costs for remote work, and in addition also has to provide the employee with all necessary means for the work he's carrying out from home or from anywhere, actually. It's not necessarily at home, close to your fridge. It can be anywhere. Another important rule, I would say, or rules, are that the termination possibilities for labor contracts have been amended. And one important amendment is that if the employer cannot reach the remote worker within 2 days, that's another reason to fire this employee. So you can stay at home close to your fridge, but you should be available more or less all the time. Okay, another, of course, issue that played a big role here is remote work based on the pandemic. And these are exceptional rules. They're also in place here in Russia. So if there's an official order that employees should be sent to work from home, which we had in place here in Moscow last year and this year in spring. So we had to send 30% of our staff working from home. Besides our law firm, we also run an accounting firm, and we send 100% of the accountants into home office. And in the law firm, we send 30% to home office. So that is an exceptional rule. Currently, this rule is not working anymore, so everybody can work in the office, which I actually personally prefer. But anyway, I think probably as a tendency in other jurisdictions, after the pandemic, a lot of people understood, oh, working from home is good for me. So it's actually really increasing. And we are advising our clients in how to structure homework in the long run. Anyway, this is all within Russia, employment within Russia, which is interesting. But what is more interesting, and now I'm coming back to the IT sector, is that first of all, if a foreign company employs or is working with Russian nationals or foreign nationals in Russia. Most foreign employees, they would probably like to spend their time in Italy, where it's nice and warm. Here the winter is long and cold and dark and gray. So that is maybe not so interesting. But anyway, from a legal perspective, it is pretty tricky. And so what I want to tell you now is the do's and don'ts about working with foreign employees on remote in Russia, if that should happen. Yeah. So I'm talking about the situation that you have a Polish company, you have a Polish employee, normally working in Poland. He decides to spend time in Russia, whatever reasons. Is that possible or not? If the purpose or part of the purpose of the stay in Russia is working here, then it is not touristic and is also not a business trip. And that has the consequence that you need a work permit. So without a work permit in Russia, you're not legally entitled to work here, also remote. That leads us to another problem. You need to obtain a work permit, and work permit cannot be obtained by an individual, but just by an organization. So you need to have a Russian employer. And foreign companies, they can be employers here, but in order to be an employer, because you also have the obligation to pay social security contributions, to withhold income tax, to pay the income tax to the tax authorities, you need to be registered here as a foreign company. So either you have a representative office or you have a branch. And for one employee, you will probably not do it, which means that there will be no legal approach to employ a remote worker here in Russia if he's a foreign national. And the breach of immigration law can have really severe consequences. The penalties are very high for the company, for the employee, and you can also be banned from re-entering Russia. And we had such a cases, so it's not theory, it really can happen in practice. And the other thing is, because we are mainly advising companies, that if you have a guy here sitting working in Russia, you can create a permanent establishment. In particular, also if this guy is carrying out sales activities, finding clients, negotiating contracts, and so on and so forth. You really have to be careful. Of course, if somebody would be here for a week or 2 weeks, as Wojciech said, probably nothing will happen. Anyway, you should really be careful because the consequences can be very, very severe. Okay, now we're coming to the next situation, which is actually exactly the situation we have been advising on this week. We have an IT company from Germany. They have a research and development center in Russia, working with around 10, 15 IT guys that are based in Russia, and they've been doing it for a couple of years. And now they came to us, and we found out, that cannot stay as it is, actually due to the reasons I will talk about now. So first of all, of course, foreign companies can employ Russian employees, but again, can only be employers if they're registered in Russia. That problem always remains. So it's not sufficient, like in Italy, you have a codice fiscale, tax number. You need to be really registered here. Either the company registers and employs these freelancers with a real employment contract. That is actually the safest solution in this situation. But that is not always what is wanted, not from the employee side and also not from the employer side. Now we're talking about this IT company, freelancers, IT freaks, to say it like that. They don't want to be employed. They want to have flexible working hours and so on and so forth. But anyway, if the foreign company continues to work with these freelancers on a permanent basis, that can also cause various risks. Also the permanent establishment risks, a risk of not paying social contributions, withholding income taxes, and the fines can be pretty high. So when employing Russian nationals here in Russia as a foreign company, you either, as I said, register company, or that is actually the second options. You have to make sure that your freelancers are individual entrepreneurs. That means they have their own tax number. They are taking care of the taxation themselves. That is pretty safe. The approach from the tax authorities here is pretty formalistic, so they are not going so much into the depth. That means if you have a contract with an individual entrepreneur with his own tax number and taxes are paid, the risk that the Russian tax authorities will say, okay, you have a permanent establishment here, you need to register, you need to pay profit tax, is actually pretty low, but you always have to bear it in mind. In our case, research and development, they're not selling, they're only spending money, more or less. They have no business here for the time being. So there is no risk that the tax authorities will calculate profit tax here in Russia and fine you because there's no business. So we have a particular situation here. Anyway, these are the two options for employing Russian or foreign nationals. Another issue I want to mention in the end is that normally we're talking about a company having an office, employees working in that office, and you also have the possibility to have remote work in different cities in Russia. Of course, yeah. So if your office is based in Moscow, you can employ people all over Russia. And since 2 years, we had already a very good improvement in the tax legislation that if you employ somebody in another city, like in Vladivostok or wherever, the company doesn't have to register for tax purposes. So that also already facilitated remote work because it's more easy for the companies within Russia to employ people all over Russia without having other technical tax issues to consider. That was a brief overview in Russia about the do's and don'ts. If you have any questions, please contact me. As I said, we are also focused on tax law. We have an accounting firm, so we can also do outstaffing and payroll stuff here in Russia. And we're happy to assist you with any issues you might have. Thank you and have a nice day.
Thomas, thank you very much. It was quite interesting, also from my perspective, because a lot of people in Poland is thinking that the legislation in Russia is some kind of the old one connected with the communistic times, etc. And what we heard from you, that in fact, in case of home office or remote work, you have very new, good and open legislation. It is completely different than in Poland, because we don't have any legislation excepting telework or just COVID rules. So in fact, it's good to follow the Russian way of doing legislation in case of the remote work, because it is good. So thank you very much. Of course, you may note that on the chat that there are some questions connected with Russia. So you will have also some homework to do with our participants. And
just one remark from my side, because that's also important, because you're talking about is Russian modern or not. We are modern from the legislation point of view, but also from the technical point of view. Yeah. The internet here is really fast and working much better than in Germany, for example. So if you have a remote worker with bad or no internet, it doesn't work. Here in Russia, the internet works everywhere very well. That's also important for remote work.
Yeah, I think that from the perspective of our guests, the Russia is some kind of the terra incognita you can recognize now, yeah, because we have a problem with the employees in Poland. It is huge problems. But in case of people who can work remotely, we are looking for the employees on Ukraine, on Belarus, but Russia is also very interesting area, and I think that some people will ask you additional questions about this. I don't know how is the salary level, because Florian said that of course in Italy the level of the minimum salary and the average salary is much higher than in Poland. But how about Russia? What is the minimum and the average salary in Russia?
Well, that's a difficult question. It really depends on the sphere of work. But if we are talking about Moscow, the salaries are very high, are also higher than in Germany.
Oh, wow.
Yes. And in the IT sphere, I think they are still, I don't know, I have no concrete figures, but since some of our clients who are in the IT business run research and development companies here, I think the salaries are competitive to those in Western Europe. And we also actually, as a law firm, have an office in Belarus, in Minsk, which is also pretty famous for the IT sector. And there the salaries are for sure
lower,
below the Russian ones, and much lower than in Europe. But this is also a permanent process developing, because as I understood now from our clients, it's also getting more and more difficult to find IT guys in Belarus and also in Russia, and that means the salaries are also going up. Yeah? That will not last forever, but the education in this field is very good. So the specialists and not only hackers you can find here still.
Okay, Thomas. So it was for you, our guest. It was also very important information that Thomas has an office on Belarus. So you can ask questions about Russia, but also about Belarus. Thank you very much once again. And as fast as possible, we are moving south, and we are in sunny and warm Spain now. So the travel is very, very interesting. I have a question from Christian. Christian, can you tell us who wants to speak? Christian? Or this was just a mistake? Okay, so let me introduce Maurice, and I give you a floor.
Good morning, bienvenidos.
Okay.
Also from my side, thank you very much for the invitation to this very interesting webinar. My name is Moritz Tauschwitz. I'm a partner and Spanish and German lawyer at our law firm here in Spain, Lozano Schindhelm. We are a one-stop shop law firm, and we also have an accounting department for all our clients. We specialize in advising international clients that want to do business in Spain. So I think I'm quite adequate partner to speak with you about the matter we're talking about today. We have offices all over Spain. I'm talking to you today from Valencia, where we have our head office. We have offices in Bilbao, in Madrid, in Barcelona, in Mallorca, in dnia. So we are represented all over Spain. I'm going to share my presentation with you and then get started. The subject working from home in Spain has been really, really popular over the last month. We've had several inquiries, and it seems quite an attractive destination to work from home from Spain. And that is why I can start with quite a good news, I hope, because of the growing interest that we noted in our clients, we prepared a short guide on the legal and tax basics on this matter, which you can find on our webpage. Just go to schindhelm.es, which is our country sign, and then look it up in the employment law section, and you will find the guide with all the information basically I'm going to give you today in a very short form and even more extensive content. So you don't have to take any notes or similar when I'm talking to you. Because we've already had so many inquiries about this matter, I can also talk to you about the practical experiences, and that's why I'm going to focus on an wholesome approach on the matter, which is I'm going to briefly mention the administrative law consequences, the tax law consequences, but I'm going to focus on the labor law level. That is what we're talking about today here. But on the if you decide to come to Spain to work from here, or if you decide as an employer to send in any legal way possible your employee to Spain so that he can keep working from Spain, these are the three basic levels that are concerned with these changes. On the administrative law side, there's one important thing, that if you come to Spain and if you have any economic relationship with Spain, you will have to get as an individual a so-called foreigner identification number, the dnia, Número de Identificación de Extranjeros. Without that, you can't interact with any authorities. If you come from the European Union, you have to register within the first 3 months in a special register for this purpose with the General Directorate of the Police. And if you come from outside of the European Union, you have to take care of the corresponding residence and work permits. I'm not going to go into details here because it's quite a complex material. But these are the administrative parts that you have to bear in mind. On the tax law side, I briefly want to mention that the main consequence when an employee is starting to work from Spain is to keep in mind when is a natural person subject to income tax in Spain. Florian mentioned this before in his presentation. It's quite similar in Spain. The basic rule is that if you stay over half a year, the 183 days in Spain, you're considered a tax resident in Spain. But even if you stay a shorter period of time, and your center or main focus of economic interests or activities is located directly or indirectly in Spain, that could be the case. And also, if your non-separate spouse or minor and dependent children, when they have the habitual residence in Spain, it can also be that you are considered a tax resident. So most probably, if you move to Spain to work from here, you're going to be subject to income tax in Spain. And if you're a tax resident in Spain, what are the obligations for you? It's the income tax that I was talking about. It can be, that depends on the community where you will be living, and the amount of wealth, of fortune that you have. It can be a wealth tax. In most of the communities in Spain, it's from 600, 700,000 euros on. You will have to present an informative tax form 720, which is not a fiscal obligation to pay anything. It's just informative. You have to inform the Spanish authorities on your fortune that you have abroad. It's for money laundering reasons. If it's more than 50,000 euros in cash or in real estate, you have to inform the authorities. I briefly want to mention a special regime, which is the so-called Beckham law, because for individuals who have transferred their tax residence to Spain as a result of moving to Spain for work or professional reasons, this is a special tax regime. It's known as Beckham law because of the former football player, David Beckham, who benefited from it back then. And the main advantage of this regime is a flat rate taxation on the wage income up to 600,000 euros at 24%, which is really competitive. For more than 600,000 euros, it's 45%. A series of criteria have to be met so that this regime can apply, and then it applies for 5 years from the year in which the Spanish tax residence is acquired, so it can be up to 6 years. This is a really interesting option when you move to Spain for work. I just quickly want to mention that if you decide to come to Spain and work as a self-employment, these are completely different rules that apply that you can find in the guide. We don't have the time to go into that details now. And then let me tell you about the labor law level, which is our main focus today. First of all, and that is really important to me, please don't take anything that I say to you as a general rule that applies without any doubts. Each case has to be assessed individually because the differences may not occur to you, but they will occur to the authorities. So really, if you plan to do that, to send an employee to Spain or to come to Spain to work, just give us a quick heads up and we can tell you what the best way is to do. Basically, there are 3 possibilities to come to Spain to work from here. It's a posting. It's the constitution of a subsidiary of your firm in Spain. But I'm not going to really talk about this alternative because basically if you do that, then the employer in Spain will be the subsidiary, a Spanish legal entity. So this is going to be completely according to Spanish legislation. There are no really specialties. It's not really an international situation anymore on a labor law level. Or we have a third option, which is to register the employer and the employment contract in Spain without constituting a subsidiary. This alternative has become in the practice, it seems for our client really attractive. I'm going to get into that later. If you decide to do a posting, you have to keep in mind that the health insurance is still covered from your home country and you pay social security contributions there. You have to apply for a A1 form in the European Union, and this situation can last up to 2 years. So basically, it's only suitable for short stays. It's not a long-term solution. It could be a solution if you want to try out the home office in Spain. You want to see whether the style of life works for you, whether conditions work for you. Then a posting can be an option. But another practical problem for most of our clients has been that there must be a receiving company. We have to report a receiving company to the authorities. And if you don't have a subsidiary where the employee is going to work, it's just not possible. But if you have a subsidiary in Spain, that's one option that you could try out for some time at least. I said before that I don't want to go into details about the subsidiary in Spain because there are no really any special regulations on labor law level, but I want to talk to you about the third option, the the register of the employer and the employment contract in Spain. If you decide to do so, these are the practical steps that you have to take. Better said, that we will take for our clients. You have to get a Spanish tax number for the employing company. And if the legal representatives of that company do not have a dnia, which is the foreigner identification number I mentioned before, we have to get them as well. You have to obtain an electronic certificate, because on this level, Spain is quite advanced. All the communication with the authorities is digital, and without that, you can't really function in Spain. Then you have to inform about the commencement of taxable activities in Spain, which will basically be the beginning of the work of your employee here in Spain. And you have to register the company with the Social Security. At the same time and in parallel, you have to draft a Spanish language employment contract. That is quite important. If your Polish employee or an employer want to send a Polish employee to Spain, we can't register the Polish employment contract with the Social Security because of obvious reasons, because they only understand Spanish, the authorities, and they won't register any foreign-speaking contract. So what we most of the times do is we have a 2-column employment contract that can adjust to the maximum amount to your actual labor contract, but we have to adjust it to Spanish law. So in terms of extra hours, for example, or vacations, you still need to meet the minimum criteria of the Spanish law. Another option could be that you just use a standard form from the Social Security as an employment contract, where you just put in the basic figures like wage and vacations, and then make a comment that as an annex, you will still continue to refer to the home country contract that can keep its original language form. These are the one-time steps necessary in this scenario. And in the following, you have reduced payroll accounting that we could, or any other accounting firm could gladly take care of, because the withholding of the wage tax and the social security contributions in this scenario will have to take place in Spain. If you decide to opt for this option of the simple register without constituting a subsidiary in Spain, there is another point that I would like to point out, which is the permanent establishment, because in our opinion, the mere registration with the authorities and the registration of the employment contract do not, in principle, establish a permanent establishment in Spain. But there are certain conditions, especially in some double taxation agreements, that it can be assumed in individual cases that a permanent establishment exists in Spain. So that is why we generally recommend that you have this possibility, this possible tax consequence briefly checked. As I said before, in this scenario, the main advantage, even because especially if you don't know whether this is going to be a long-term solution for your company, is that you don't need to constitute a subsidiary. But of course, it is possible as well. On this regard, and you can also find more details in the guide. And to finish, I want to mention that in Spain, we also do have a really new, if you see the date, we have a new legislation about working from home. It's the so-called remote work law, de trabajo a distancia. Is especially designed not for corona-related remote work. It goes beyond that. So it's really thought of to be a model for the future for hybrid working models. According to this legislation, there are a series of obligations and formalities that have to be made. It's really complicated, and you have to make a list of all the inventory. You have to, as a company, as an employer, you have to pay all the costs, even the electricity, the proportional part. So it's really quite complicated to fulfill all its criteria. But the good news, so to speak, is that it's only applicable if the actual activity does not place in the registered work center. So what is the practical consequence is that when we register a foreign employer and the employment contract here in Spain, we just put in as a work center the home address of the employee. So like that, we can avoid that this law applies with all its strict regulations. that's from my side, my presentation. I'm looking forward to all of your questions and for discussion and to the rest of the presentations of my colleagues. Thank you very much.
Thank you, Marit. It was very, very interesting. And we have another country with new modern legislation concerning remote work. What I can add, yeah, a lot of formalities, but in fact, to avoid any problems and any disputes between employer and employee, remote work in fact has to have quite detailed legislation, and we in Poland still waiting for this. I'm repeating this once again. Maurice, of course, you are very popular, so you have some questions on chat. Even the link for your own presentation from Lozano Schindhelm. If you want to travel to Spain or doing business in Spain, you can see that Lozano have offices in very beautiful places. So just use them. Okay. So we are not traveling. Now we are knocking to neighbor's door. We are in Czech. There is not only knedličky, not only beer, not only good food and Szwajk. It is also the country of business. And very close to Poland. So I'm giving you the floor. Jan, just tell our guests about Czech.
So, Wojciech, thank you very much for a nice introduction. And once again, I would like to thank you for inviting us to this event, to thank all of our guests for coming. And now I can briefly say something about our office. So, my name is Jan Hvalek, and I'm attorney at law in Pilsen. Our law firm, zapis Schindhelm, has offices in the Czech Republic, in Prague and in Pilsen. We are also working closely with our office in Slovakia. So we are using close cooperation, and this is also the reason why I will have another presentation about Slovakia in a few moments. Now I will start sharing my presentation. Okay, so to start with, let's imagine a situation that an employer, for example, a Polish company, wants to have an employee in the Czech Republic, and the employee wants to work from home, to work from home office. The question that should be asked first of all is this even possible? And I can say the answer is positive, and not only it is possible, but it becomes quite common in the latest time, and especially following the COVID outbreak in the last years. So from legal perspective, from the perspective of the Czech law, there is no problem with that. As my colleagues already mentioned, there is regulation on the level of the European Union, dealing with the situations where there is international relationship between employer and the employee. And first of all comes the choice of law made by the parties. So if the employee and the employer agree, okay, we will have the employment agreement and it will be according to Polish law, and the employee will be working from the Czech Republic, then it is the way to go. And usually I can say that the clients decide to choose the law applicable according to the seat or the country where the employer comes from. It's the usual practice, but sometimes employees may want to choose the law of their country. So, for example, of the Czech Republic, both is possible. If there was no choice of law, then the law would apply of the country where the work is habitually carried out. It's a rare instance. Usually there is a choice of law in the contract, but this provision has some consequences. That means that even if an employee works from the Czech Republic on the basis of employment contract under Polish law, then he cannot be deprived of the protection which is secured by the Czech labor law. This is something which has to be taken into consideration when some employee and employer are thinking about establishing such a relationship. Now I will briefly talk about what is the protection of the employee under Czech Labor Code. Here you can see some examples, and first of all, I may say that basically all provisions of Czech Labor Code that are meant to protect the employee cannot be changed by the contract and deprive the employee of his protection. Maybe some of the most important protection of employees under Czech law is the strict definition of reasons. How can the employment be terminated? It can be terminated by notice only for reasons which are stipulated in the labor code, and there is a strict definition. Maybe some reasons are different from the reasons which the employers are used to from their home country. So it is this wise idea to check this when planning this relationship. Then may come into question the minimum of the notice period for the employees under Czech Labor Code. Basically, the notice period under Czech Labor Code cannot be lower than 2 months. So the employers must always count with that once they give the notice, they must take into consideration the notice period, which is 2 months at minimum. Then the Czech labor law has some instrument, maybe common to some, other legal systems, maybe not of probationary period, when the employment may be terminated following its establishment. So it means it's in the very first months of the employment. And then no special reason is required. Basically, it can be terminated for any reason whatsoever from both sides, the employer and the employee. And under Czech law, this period can be 3 months at maximum, or 6 months in case of some employees which are on higher level of the employer's structure. Then another important issue, and what the employers quite often ask, is the minimum wage in the Czech Republic. To give you an example, in case you are interested, the minimum wage in the Czech Republic is currently 15,200 crowns per month. So this means roughly 600 euros. And in case of our wage, for 1 hour, it is divided by 40 hours, which is the working hours, standard working hours under Czech Labor Code. So it is 90 crowns, 0.50. The Czech labor law has another aspect besides minimum wage, which is guaranteed wage. This means that not only the employees are entitled to the minimum wage, but depending on the level of their skills, qualification, and difficulty of their job, they are entitled also to so-called guaranteed wage, which is always multiplication of the minimum wage. The minimum wage and the guaranteed wage are changed every year on the basis of regulation of the Czech government. Then another aspect to be taken into account may be premiums for overtime work, for the work on weekends, and for the work on holidays. Basically, just to give you an idea, the premium for the overtime work in the Czech Republic is 25% of the basic salary. On weekends, it's 10%, and on holidays, the employees are entitled to twice their usual salary, unless they have a day off instead of this extra salary for the work on holidays. The Czech Labor Code also has some limits for the maximum duration of employment if it is for a fixed term. So let's say employer and employee conclude the contract for 2 years, which then shall expire. And the Labor Code says that they can repeat this only twice. So the employment contract for a fixed term can be repeated twice between the same employer and the employee continuously. And at the same time, the maximum duration of the fixed term is 3 years. So it's 3 years, and 2 times repeated means 9 years in total. And what is maybe common to Czech labor law is the delivery of notices, which is quite strict and has a lot of formal requirements. So we always recommend our clients to review the employment contracts if they want to establish such relationship. Now let's talk about the home office in the Czech Republic. I have to say that in the Czech Republic there is no comprehensive regulation of home office, and this is the reason why I can't say much about the regulation of the home office, because now there is no statutory regulation. There is an amendment to the labor code which is now pending in the parliament, and although it should have been in effect from the 1st of July 2021, it is still pending and it is not clear when it will come out. It is expected that the regulation of home office will be similar to other countries in Europe. As is the state now, the home office cannot be ordered by the employee or ordered by the employer or requested by the employee, but it always requires an agreement between both parties. And because of the lack of the statutory regulation, we every time recommend our clients to conclude an agreement on home office and to regulate all duties, obligations of the employer and the employee. What kind of equipment will the employee get to work from home? What kind of compensation for costs will the employee get? Because the statutory regulation is missing now. Anyway, there is a common agreement that even on home office, the employer is responsible for the occupational safety and for work accidents of the employee. The next slide considers the questions of what kind of permit for work or residence is needed to work from the Czech Republic. So the rules are basically the same for the whole European Union and EEA, meaning that citizens of the EU and EEA can work in the Czech Republic without any work permit or residence permit, and they only need to report to the foreign police if their stay exceeds 30 days. Another topic which a lot of our clients ask about is posting of third country citizens to the Czech Republic to perform work. We are talking about the third country citizens who are working and residing legally in another EU country. And it is quite common practice that these citizens are being posted to the Czech Republic to perform work. But we always warn our clients that this is a practice that is strictly watched by the Czech authorities because of the strict restrictions, and they are checking if really this is a posting of employees, meaning that they are performing work based on the contract between their employer from another EU country and between another party in the Czech Republic. And they are strictly watching if this is not bypassing the law dealing with legal work in the Czech Republic and the residence of foreigners. Maybe if some of you is interested in more info on this topic, I have some links to more information from the inspection of work of the Czech Republic in Polish and in English. Because now I can see that my time is running out, I will just shortly talk about the social security implications, which are again pretty much the same in the whole EU. Always, basically, we can say that the social security should be paid in the country where the work is performed, based on the rule lex loci laboris. Should there be a case of an employee who works partly from one country and partly from another country, then the situation is not as clear as if he is working from one country. And then this situation must be reported to the Czech Social Security Administration, which then decides where the social security contributions are due. As regards the tax implications, of course, there is plenty of double taxation agreements between the Czech Republic and other countries, for example, with Poland from 13 September 2011. The important question is if there is permanent establishment or not. In Czech it is called stála provozovna, because then the taxes would be due for both the employer and for the employee in the Czech Republic from the moment it is created. Of course, there is also the rule of the duration of work of 183 days as in other countries, and then basically the income becomes due. The tax from the income becomes due in the Czech Republic. Because it is quite complicated and there is a lack of decisions and opinions also from the part of the tax office, it is possible to consult the tax office in advance and ask for their opinion before this relationship begins. And then the advantage is then the employer can rely on this opinion, and in case of any inspection, the employer can refer to this opinion so that he does not breach any tax duties. So I came to the end of my presentation. Here are the addresses of our offices in the Czech Republic. And thank you for your attention.
Jan, thank you very much. So now we know that, of course, in Czech we have very interesting regulation concerning remote work, and also as our neighbor, the Czech and the business country Czech are very interesting for Polish investors. We can note that because of the tax reasons, a lot of Polish entrepreneurs, they are starting business activity in Czech. maybe it is worth to consider the employment from Czech, because I expect that after some tax and social security changes in Poland, which are in a future, closest future, maybe the Czech will be some kind of the alternative for the employment. So if you are, if you want to check it, just ask questions to Jan on our chat. Of course, we will give you some break, because there is a lot of information. We are traveling through Europe very, very fast. So we are giving you 15 minutes break, and after this 15 minutes, we are returning from or with Slovakia. Jan will return to us and will tell about some differences in working remotely from Czech and Slovakia. So please return. Now you can organize some good coffee from Italy or good tea, and we are waiting for you within 15 minutes. Thank you.
Thank you.
Hello again, everybody. So we are moving, still moving, not very far from Czech, but to neighbors, another neighbors, to Slovakia, and we have still Jan. So Jan, could you tell us how everything connected with the remote work works in Slovakia?
Okay, so thank you once again. I will start the presentation. First of all, to tell you why are you hearing me again? This is because we have also an office in Slovakia, in the capital city of Bratislava. And due to the history of our countries, Czech Republic and Slovakia, you probably know former Czechoslovakia. There is a close connection between both legal systems, and this is quite common practice that many lawyers from the Czech Republic and Slovakia are practicing in the other country. The legal systems of the Czech Republic and Slovakia are completely separated now, but have a lot of common history. There is still a lot of acts and laws which were passed before Czechoslovakia was separated, and they are in effect in both countries. And since 1993, we are going our own ways in terms of legal systems. Again, let's try imagining a situation that foreign employer wants to employ an employee in Slovakia. Maybe again they ask, is it possible to employ an employee with our firm from Poland and have an employment contract under Polish law with this Slovak employee and have this employee working from Slovakia? The answer is again yes. Even in Slovak labor code, there is a stipulation that Slovak labor code shall apply to employment relationships between employees working in Slovakia and foreign employers, unless provided otherwise by regulations of international private law. So it is officially approved by the labor code. What is meant by the regulations of international private law? Well, basically the regulation Rome 1, which I was speaking about, and its rules for choosing the law applicable. applies, of course, in the Slovakia the same way as in the Czech Republic. So always must be observed the provisions of the Slovak Labor Code, providing protection to employees. They are again quite similar to the provisions in the Czech Republic, with some minor differences. Just to give you an idea, in Slovakia the notice period is depending on the length of the employment and varies between 1 month and 3 months. The often asked question, the minimum wage in Slovakia is, I must look into my files, it's currently 623 euros per month. When divided by the number of working hours, it is 3.58 euros for an hour. With this is connected the maximum amount of working hours in Slovakia, which is 40 hours. And in terms of annual leave, the basic length of annual leave is 4 weeks in a year. And for employees older than 33 years or employees who are taking care of a child, the minimum annual leave is 5 weeks. Again, the Slovak labor law provides some premiums for overtime work, for work on weekends, and for work on holidays. On holidays, it is again 100% premium to the basic salary. As regards overtime work, the premium is basically 25% of the salary. There is also a limitation of contracts for a fixed period, similar to the Czech Republic, but with a small difference that the contract for a fixed term may last only 2 years, with the possibility of extension 2 times. So once again, it is very important to review the employment contract. Maybe if the employer wants to use some template of the employment contract using in their country, then it is really strongly recommended to review it before using it in the Slovakia. In terms of home office, I can say that Slovakia is ahead of the Czech Republic regarding the home office regulation. In Slovakia has been already passed an amendment to the labor code introducing the regulation of home office. This regulation says that the rules of home office apply only in case that the work from home is performed on a regular basis and not only under extraordinary circumstances like, for example, pandemic. So if the home office is only a result of some extraordinary situation, it is not treated as home office by the labor code with all the rules for home office. Again, there must be an agreement on the home office between the employer and the employee, except in one situation about which I will be talking later. It may be stipulated that in home office the working hours will be chosen by the employee. So the employee may decide if they want to work in the morning, then maybe in the evening or even at night. But in such a case, they are not entitled to premiums for work on weekends, for overtime work, etc. The employer, of course, has to provide an employee with equipment, with proper equipment to perform work from home, for example, computer. And also provide some compensation of employees' costs connected with home office, for example, for the electricity or maybe some tools. And of course, again, the employer is responsible for the occupational safety and work accidents at home office. This is quite interesting topic, and it's quite a question how it's gonna end up once we have some court decision in this respect. Because the question is how the employer should check occupational safety at the employee's home. Not very easy, but the employer is still responsible for work accidents. Before I was talking about one exception when the home office in Slovakia can be ordered by the employer or requested by the employee, and this is at the time when anti-pandemic measures are in effect in Slovakia, when the authorities declared this special measures, then the employer may order the employees to work from home. Or the employees may request this, but of course, with the condition that the work from home is possible. Mainly, it concerns jobs from offices, like, for example, lawyers. So, and not to, what is also important to mention is that the law explicitly states that the employer has to provide an employee in home office with an opportunity to come to his workplace, workplace at the employer's workplace. That means that the employees may meet their colleagues at the workplace, and is meant to prevent isolation of employees in home office, maybe some health problems, and we expect this provision to be passed also in the Czech Republic. And one other interesting aspect is that employees working from home have the right to be disconnected during their time off. That means that once their shift is over, their employer may not require them to be still connected, to be still online, but must give them some time to relax. Yeah, I expect that this will be quite common across all the European Union, this regulation to have the so-called right to be disconnected. To shortly mention the regulation of work permit and residence permit in Slovakia, it is of course the same as in the rest of the EU. So EU and the European Economic Area nationals may work without any further requirements of permits. And the third country citizens require residence permit and work permit to perform work. The posting of employees from other EU countries is, of course, possible again. And now the social security questions and tax questions are again pretty much the same due to the EU regulation. Again, the rule is that the social security should be paid in the country where the employee is working. And in terms of taxes, it is the most important topic if there is a permanent establishment in Slovakia, and then comes into question the period of 183 days, when basically after this period the taxes on incomes become due in Slovakia, even if there is no permanent establishment. Okay, so now I won't delay you any longer, and thank you for your attention.
Okay, thank you very much, Jan. We know that there are some similarities and some differences between Slovakia and Czech, so you have to be very careful. Just in case of investing or employment in Czech or Slovakia, just contact Jan. Jan, you can check if there are any questions on the chat. And what can I say? We are very close to winter, and what can be more tempting than skiing, drinking good wine, and dancing waltz? So we are moving to Austria. Roland, are you with us?
Good morning, everybody. Thank you for your invitation, and thank you for your spreading leading to the Austrian part. And as everybody knows, the current home office regulations that came up or were established in all countries is something that is closely related to the COVID pandemic, and everybody is obviously aware that it's a more difficult situation during winter. And let's start with the Austrian regulations in this regard with home office. Just give me 1 minute to find my presentation. Here it is. So in Austria, the home office law, or the home office regulations, better to say, have been established in the beginning of this year in April, and there was a long discussion already before until until this date or until this new regulation, we had no real or no specific home office regulation or no home office code. And we were working with some other legal instruments ruling doing work outside of the company, which was, of course, widely unsatisfactory. What are the contents of the Austrian regulation? Primarily, it is to say that we have no uniform law code on working in home office, but there were some new regulations established in the general employment law code. What are the specific regulations? First of all, the definition of what is considered as home office is rather narrow, because it is something that or the work of the home office work or the place of home office work is where you actually live. So the home office law code is not intended to allow or to rule home office work in your vacation residence or somewhere else abroad or somewhere else when you're traveling, whatever. So it is specifically designed to do home office work at home where you have your residence. This is a very important point, because it's also closely related to questions with accidents and the related questions of insurance. Further, it is the regulations rule that we need an agreement between the employer and the employee. The law code says that we have to have a written agreement, but in general, an agreement in a written way is just to prove that there was an agreement between employer and employee. It's not a constitutional criteria of legal home office work. It's more for evidence. Anyway, there is no entitlement for one party to enforce home office work, neither from the employee side nor from the employer side. So it always needs to have an agreement. Important is that the days are explicitly defined, or that there is a ruling defined which home office days are, or how the home office days are defined. So can be a specific day, can also be a number of days during the week, whatever. Working time, obviously, is somewhat a little bit different from your countries. In Austria, the basic rule is that during home office work, your usual working times that you have agreed with your employer, also for the situation doing work in the office or in the company, is the same also for the home office work, the same working times, unless you make a special agreement and in contradiction to the initial working times. You can, of course, agree on other working times, but this requires a mutual agreement. If there is no such other agreement, the working time rules as agreed with the employer apply, and also the working time rules from the working time law code and also the rest time would apply in home office. A critical point is also the availability or the provision of work equipment, and here we have a differentiation between digital work equipment and other work equipment. So basically, employer is obliged to provide the necessary digital work equipment for home office work, meaning mobile telephone, laptop, computer, whatever. On the other side, the employee has to provide his own desk or chair, whatever, or any other non-digital work equipment by himself. If employer does not provide the digital work equipment, the employee can reimburse costs if he had to buy some equipment. Which is mandatory, this reimbursement. So, as I already said, we also have a regulation on work-related or home office work-related accidents. Until or before the time of these new regulations, employees in home office had a very big risk that they were not covered by the social insurance if they had an accident in their home office. Also during home office work, there was a very strong and a very narrow jurisdiction from the civil court, and this was changed to the advantage of the employees, so that they are also covered by the social insurance if they have an accident in the home office, or on the way to the home office or from the home office, like doing, for instance, bringing the kids in the morning to the school or kindergarten and go back to the home office work at home. Also, these ways are covered by the social insurance as an work-related accident. So this is a very good improvement to cover social insurance and accidents. Last but not least, there are also some special advantages in relation to taxes. So the employee has the possibility to deduct his investments related on the number of days of home office work, and on the other hand, if the employer pays to the employee a certain amount, a lump sum, whatever, to cover the costs for digital equipment or other investments, you can, as an employee, deduct this payment, and it is not entirely taxed as a salary. So I think we have a very small field that is regulated by the Austrian Home Office laws. So mainly, you can summarize this that the provision of work equipment is regulated. It is regulated how home office work is to be established, meaning by mutual agreement. We have the social insurance protection for accidents, and we have some tax advantages, and this is more or less the package of the Austrian home office regulation. And not to forget that home office is really related to the place where you live and not somewhere else. Yes, that's it from the Austrian side. Thank you for your.
Okay, thank you very much, Roland. In fact, what we can see that we have the common problems. Yeah? The main problem in Poland is that we don't have the regulation, and I can observe that we are probably the last country in European Union without such a regulations. And of course, the main problems are the same everywhere. Yeah, the working time, the cost of the remote work, etc. And I want to share with you some thoughts about maybe not the thoughts, maybe the result of the survey, because I had a lecture to one of my clients about mental health problem and the legal aspects of mental health problems at work, and I usually I did this lecture before COVID, and now one of our clients asked me to do this lecture once again, and I was trying to put some let's say COVID situation into the mental health of the employee situation. And what I can say, and what is very important, and probably the very important for every country we have now, that according to the survey result done by Hayes, the average working time during home office is 1.5 hours longer than normal working time at home. At work, at office, in office. So what you have to consider that people working remotely, people working from home, they are working much more than usually. And of course, in case of overtime, in case of overload by work, it is very, very important, and it can cause legal problems. It can cause the mental problem. Why I'm sharing this survey result? Because I'm returning to the Jan presentation, and he said that Czech and Slovakian registration, has the right to this connection. And we are we have huge discussion in Poland about such a right, because as far as I remember, the France started with such a regulation. I hope that Maurice will tell us something about this during his presentation. But when we combine those two issues, one, that we are working from home much more than from office, and that we want to have, because according other survey results, almost every employee wants to have a right to disconnection. It shows us how problematic the remote work is, and we can say that we are working remotely for more than 1.5 years, but we still don't have the results of such a big number of people working alone. Yeah? And of course, there is not only the legal problem, not only the legal issue, but considering remote work, you should take into consideration all these areas, let's say, not only legal ones, but also the mental ones. Nevertheless, thank you very much, Roland. It was a pleasure to have you during our webinar. And I said about waltz, I said about wine, I said about skiing. But before this, we have October. And I have strong connection, of course, Oktoberfest in Germany. So if you want to travel to Germany and being a part of such a big fest like Oktoberfest, and maybe you can work remotely during, of course, not drinking, but during stay in München. Lucas, tell us about this.
Yes, hello, thank you very much. Yeah, if I want to go to the Oktoberfest, unfortunately, I will have to work remote as well, since I'm sitting in the very north of Germany. Yes, Well, thank you very much. Hello to everyone out there. I'm Lukas Behnke, Schindhelm lawyer from Osnabrück. We have just a few words about us. In Germany, we have 3 sites: Osnabrück, about 20 lawyers, Hanover, and Düsseldorf. And well, yeah, we're doing pretty much every questions related to business law. So especially employment law, that is my specialty. So that's why I'm here, and I'm happy to give you a little overview over the particularities of home office in Germany. Oh, hang on, I will put on my screen for you. I've forgotten about this. I hope everybody can see my screen now, and I will start.
Yes, everything works.
Perfect. I will just change it to the whole monitor. Perfect. Thank you. Yes, and I will try to keep my presentation compact. We have had a lot of input so far, and we have a lot of good explanations ahead. And I think a lot of this stuff is quite comparable with regard to the applicable law and the social security law, since it is based on European law. And I think to have a little conclusion in the first place, I think that's quite good news. It basically means, in my opinion, as an employer, you do not have to establish a different system for every country in the European Union if you want to send someone to the home office in another country. So that is quite good news in my opinion. But yes, about my contents, it is also quite comparable, of course. I will tell you a little bit about the legal framework we have in Germany at the moment. I will say something about the employment law, and which is my priority, of course, and social security law. And tax law, I will not go into any details. It is the same questions in Germany. Where do I have to pay my income tax? Do I have to pay it partly in one country, partly in another country? But it is still really depending on the European legislation. So it is the topics are the same as in the other countries. Yes, starting with the legal framework in Germany. At the moment, we just do not have any specific codification, and there is only the general rules at the moment. And when drafting them, nobody had in mind home office is going to be a serious option, and nobody had in mind it is going to be that big. So we're in kind of a very interesting transition phase. Of course, these general rules, they open a lot of space for discussion and argumentation, and this makes an individual assessment very important each time you talk about home office issues. I will give you some ideas in the following, but this is very important. Yeah, and well, I think you said Poland might be the last country in Europe to be to have a specific codification for home office. I think it's going to be Germany, because we do not have any intentions at the moment. We used to have an initiative by the Ministry of Labor at the beginning of this year, but it didn't go through Parliament in the end. It couldn't find any consensus there. And this is especially because it contained a right to work in the home office for every employee under German legislation. So this goes quite far, and this is the reason why it couldn't find any consensus. But at the moment, there are no current discussions, and there seems to be no drive to find a greater codification at the moment. Well, these discussions might come back again after the elections, since we're facing elections next week in Germany, and polls seem to see quite good chances for a social democrat to be the next chancellor here in Germany. And since the initiative early in this year came from a social democrat, this topic might come back again, and maybe with the right to work in the home office for every employee. But at the moment, there are no dynamics in this discussion. So we stick with our general rules. Yeah, having said that, I will start off with the employment law, and of course, nothing I'm going to be able to explain about German home office rules or employment law does make any sense if German labor law isn't applicable. And without going into into too much detail, since we heard that already, it is of course important, or it is of course in the first place free to the parties, employer and employee, to agree on the applicable law. And we've also heard the great exception is if there are indispensable and for the employee favorable regulations in the country where the work in the home office is performed, then this law applies. So we've heard this is pretty much a really great risk of unpredictability, or we call it here patchwork of governing law. And since we have quite a high standard of employment rights, and you hear it is a discussion to have a right to work in the home office, there are also a lot of indispensable and very favorable regulations in Germany. So it is not that easy to agree on a different governing law without having German regulations being applicable. But however, it is always, in my opinion, a very unique decision, and there might be reasons to decide whether a different legislation should be applicable on the employment in Germany. But it should. The important message is to be aware of it and to assess that question individually. And that is, I think, the most important point with regard to the applicable law. Since it has been a quite big discussion in Germany, I want to talk about a little bit more detail about a right or obligation to work in the home office in Germany. Of course, at the moment, we do not have a right to work in the home office. An employee cannot claim, I want to go to the home office and work from there, even not during pandemic or for healthy reasons. As far as I have seen it, there have been no successful lawsuits for such claims. Of course, there are discussions about it, and some people say there can be a claim in exceptional situations, but there haven't been any exceptional situations obviously being decided. So no right to work in the home office unless there's an explicit agreement, and of course such an agreement can be the employment contract. It can say you have to or you're allowed to work in the home office, you're allowed to work in the home office for 2 days. All the boundaries can be set in this employment contract. There should also well, at least it should be thought of a revocation to work in the home office, or for the right to work in the home office, and all that should be stipulated in a proper individual agreement. So such an agreement can enable to work in the home office. And also a right to work in the home office might come from a works agreement, and such agreements will become more in Germany. Since end of June this year, the works councils in Germany have a right to be included when a company is establishing a whole system of home office for the company. So a greater system, not an individual decision to send someone to home office, a greater system, everyone is allowed to work in the home office. Then the Works Council has a right to be included, and they will, I can tell you that, they will come to the employer and say, we want to establish such a system. So this opportunity will get bigger and bigger. Even if there is an explicit agreement to work in the home office, that doesn't mean the employee is allowed to work under German labor law to work in the home office abroad. So if they want to just continue their vacation for another 2 or 3 days, this needs another further consent of the employer. So working in the home office doesn't automatically mean it is also allowed to work abroad in the home office. I think that is quite an important point. And I guess a lot of employees are not aware of that in Germany. Well, on the other side, there is also no obligation to work in the home office. If someone really doesn't want to work in the home office, there's no way to enforce to go there. And that might be a topic for a company which is working with flying desks, which is working with a booking system to spare rent. And I think there will be more employers who will do such things, and they should always keep an eye on the possibility to send someone to the home office, because without someone's consent, that is not possible. Other than that, if there's no explicit agreement, of course, the employer can define the extent of working in the home office. They can say, yes, you are allowed to work in the home office without or with such as a granting of home office. And they can also say, yeah, that was only a once-time opportunity. You have to work in the office again. That is all possible in Germany, but if you do it home office and allow home office without an explicit agreement, there is the risk of a so-called company practice in Germany, and this is pretty much a repetitive practice for all the employees, and they build trust, and this trust can build up to an actual claim. So such granting home office without an explicit agreement should be monitored very well and assessed individually to avoid such company practice. It is better to have clear regulations for home office in Germany to avoid a company practice. Of course, employment law is always related to work safety, and in this regard, we also in Germany have the differentiation between remote work and home office. We know it is pretty much the same as my colleagues have explained. Remote work is the opportunity to work everywhere. Home office is a fixed installed office in the residence of the employee. So, and only for this home office, there are in fact some specific legislations in the Work Safety Act, and but it's only a few and not really helpful. But there is a need for a specific hazard assessment in the home office. There is a need of a specific instruction, and also there are specific requirements for computer workstations in the home office. And well, this needs to be considered when thinking about being compliant in as the employer when granting home office. And well, it is always a quite complicated situation to be compliant here, because nobody wants to have the employer in his house. So lucky enough, at the moment, authorities does not seem to have to be concentrating on work safety in the home office. But this, as home office issues are getting bigger, this should be monitored, and it might be that authorities might change and focus on such things. So this is something to be up to date, always up to date. Of course, other aspects are also the Works Council. I've said they have a right to be included, which is very important and will have a big impact in future. Data security, we've heard that. There are especially the restrictions of printouts or such measures. Should be assured there are no accesses for unauthorized third parties, such as family members, and also the working times are quite a big problem. We've heard about the problems from my colleagues before. It is the same in Germany. Working times and free time is pretty much going into each other at the moment, and we will see how that is going in the future. Yes, and at the end of it, social security law, we've heard the social security law is applicable depending on the state where the work is performed. It is very easy for someone who has regularly performing the work in one state. It is more complicated if someone is regularly performing work in 2 states. There's a great chance the social security law is applicable of the state where the employee is residencing. And also, my colleagues have said, and it's absolutely correct, the marginally performed work in more than 1 state is at the moment subject to a lot of unanswered questions. Usually it is not a big problem at the moment, but there are legally, it is a gray zone at the moment, and we do not have clear guidelines for that. But usually it does not cause any bigger problems at the moment. But we will see and have to monitor the developments in the future. In Germany, the impact of COVID-19 did not affect any social security obligations. The social security agencies have agreed on that there's no impact of COVID-19 during changes, and this is only for a limited time. So after that, there is the risk of changes of the usual working times in one state and the other, and this is something which is always a compliance risk. So some formalities, we've already heard about it: notification to residential social security agency if someone is working in 2 states. A1 certificate is something to be aware of. And for the marginally performing work in 2 states, there might be the opportunity, it is not decided eventually or finally at the moment, but there might be to have legal security due to an exceptional agreement between the social security agencies of 2 countries. They can find a binding solution or binding solution for the social security law applicable. But we will see whether they actually are going to do that. And as far as I have seen it, no clients of us have done it before, but it is definitely a way which might be a solution in the future. So yes, I had my little conclusion in the beginning. I think harmonized EU law makes working home office in Europe easier. I think that's good news, and I think this webinar gives you a very good, or raises the attention to the issues at hand. So for all the states we have, so I think it is a great opportunity, and thank you for your attention.
Thank you very much. Thank you very much, Lucas. We had some technical issue that we didn't see in the last pages of your presentation, because now we are seeing the telework from France. So maybe France took some German part. Neighbors. Okay.
I'm very sorry.
Not a problem. What I can say that, of course, if you want the presentation from any country, just ask. I will give you my my email address. Guys, I want to ask you every lecturer that you will put your email addresses on the chat. So everybody who wants to contact you, he can do it via email. And of course, I will put my address. If you want any presentation, just feel free to ask. We will send you the presentation. Of course, finally, every guest will obtain the link to our record of this webinar. So. Once again, Lucas, thank you very much. And of course, you are right that maybe we are not last, but what we have to say that the German point of view of labor law is a bit different than Polish one. We have a lot of governmental parliament regulation. In Germany, as far as I know, the collective agreements, collective bargaining agreements are much more important than in Poland. Of course, we have some collective agreements, but usually it is in the, let's say, public sector. In private sector, they are not very popular. In Germany, it is completely opposite. The let's say public regulation, government regulation is not very complicated. It is quite simple and gives the parties, employee and trade unions and the employer, right to decide by themselves. Yeah, in Poland we are, let's say, teaching this way of making an agreement. Yeah, so we have a lot to do in that area. So I can say that probably Poland needs such a regulation much more than Germany. Okay, so. We were talking about the presentation, but of course we are moving to another beautiful country, another country of wine, another country of nice weather, and one of the biggest countries in Europe, and of course the business country. So we are in France. Maurice, I give you the floor. You are muted. You have to unmute.
Yeah, thank you. I was saying thank you, and I was saying I'm sorry. I uploaded my presentation a little bit too soon, so Lucas, I'm sorry. So my name is Maurice Hartmann, and I have been managing Schindhelm's brand new French office in Paris for almost a year. And to make it brief, in France, we mainly advise companies in various aspects of business law. So to the teleworking from France. Firstly, I would like to specify that without wishing to be unkind to my colleague Brand from Russia, I would like to exclude from my presentation the situations concerning non-EU states, since they depend on bilateral agreements with France. To the issues, firstly, to the issues relating to the applicable social security legislation. First, a quick reminder of the principles of affiliation. All my colleagues from Europe already mentioned it, but there is the principle of uniqueness and territoriality. According to this principle, any person who carries out his activity on the territory of a member state of the EU or who carries out at least 25% of his working time in the state of residence is subjected exclusively to the social security legislation of this state. As a result, an employee working in France must in principle be affiliated to the French social security system, except in a special situation such as a posting, which allows the employee also working on the territory of another state to remain affiliated to the French social security system under certain conditions, or if he is coming from Poland, for example, he remains affiliated to the Polish social security system. To the situation related to the health crisis. The principle was still the application of the rule of uniqueness and territoriality, but on a temporary basis in order to avoid a change in the applicable legislation due to this unusual situation. French and several member states of the EU, the EEA, Switzerland and Monaco have agreed that this circumstance will not affect the social security system regime applicable to frontier workers, expatriates, multi-workers or posted workers. This was relayed by the French Social Security Department, which this flexibility, which was supposed to apply until the 30th June 2021, has been extended until the 30th September 2021. even though several European countries, I think, have already decided to neutralize this period until the 31st December 2021. However, this flexibility only applies to the cases provided for frontier workers, expatriates, multi-workers, and posted workers within the meaning of the EU regulation. On the other hand, an employee usually employed in the EU country, in a EU country who has decided on his own accord to move permanently to France while continuing to telework for his original employer should not be covered by this tolerance and should be covered by the French social security from now on. So now we have to think a bit further and to think about the aftermath of the health crisis. If the practices of teleworking were to continue after the end of the health crisis, it would, for the moment, due to the current French legislation, be necessary to revert to the strict application of the rules defined by the EU regulation in the absence of a specific provision for telework, which would lead in some cases to use the social security legislation of the place where the activity is carried out, meaning the place of telework. This situation is not without consequences for the employer, who will have to register with the social security bodies of the place of activity, so for instance in France, and sometimes it implies an increase of the costs of the employee. I'm thinking of the situation of a Polish worker who will telework from France. The costs for the employer of the employee will be much higher, since in France the minimum wages and so on are drastically higher as in Poland. So if telework is carried out on a residual basis in another state, or if it is carried out there on an occasional basis, the European Commission considered that this is insufficient to justify a change in the applicable social security legislation, which must remain that of the place where the teleworker mainly carries out his activity. On the other hand, when 100% of the activity is carried out by telework in the state of residence, or if the telework has the effect of increasing to more than 25% the working time carried out in the state of residence, the situation is more complicated. In such a case, it might be tempting to resort to the practice of posting, for instance. This allows an employer who is legally established in one state and carries out his activity there to temporarily post an employee to another state to carry out an activity on his behalf. So provision of service, exploration missions, and so on. And during this time, there is a retaining of the benefits of his original social security system. However, this solution is not always satisfactory because the situation does not really correspond to the definition of posting. On the one hand, the performance of the work in another state results less from the employer's activity than from the employee's will. On the other hand, as the posting is necessarily agreed for a maximum period of 24 months, it cannot constitute an appropriate solution in the event of that telework is organized in another member state on a permanent basis. A final solution could be to ask the competent authorities of the state concerned for an exceptional individual derogation from the rules on social security liability, as recommended by the French Social Security Administration. However, it seems that, once again, This solution is only possible if the telework situation is implemented for a temporary and determined period. So, to the issues relating to the applicable labor law legislation, it's pretty much the same as in Italy and other European countries. There is a principle: the parties are free to determine the law applicable to the contract. It is Rome 1. In the absence of a choice by the parties, the applicable law is that of the place where the employee habitually carries out his work. Thus, in the absence of a choice by the parties of the law applicable to the employment contract, the habitual exercise of the telework activity on the territory of a state other than that of the establishment in which the employee was working until then could have an impact on the law applicable to the contract unless this exercise is of limited duration, such as during the period of confinement during the crisis of COVID. As an example, the employment relationship between a German company and an employee hired to work in Germany would, in the absence of a choice by the parties, be subjected to German labor law. If the employee were subsequently to carry out most of his activity from France by teleworking, French law would govern the entire employment relationship. So to avoid this, it may be tempting to fix the applicable law in the initial employment contracts or in a rider establishing telework. However, this solution does not solve all the difficulties. According to the EU regulation, the choice of the applicable law by the parties cannot have the effect of depriving the employee of the mandatory provisions of the law, which would be applicable in the absence of a choice. And these mandatory provisions are defined by each national law. Therefore, even if in our example where the parties have chosen to apply German law to their contractual relationship, in case of teleworking in France, the mandatory provisions of the French law will have to be applied. And the mandatory provisions of the French law are pretty heavy and numerous. It is generally considered that the French provisions set out in the French Labour Code, which constitute the hardcore of the rules applicable to in the event of posting, concerning compulsory rest, right to strike, non-discrimination, equality between men and women, etc., constitute mandatory rules of French law. And in addition to that, the Court of Cassation, the French Supreme Court, has also had occasion to specify or to add other provisions of French law, which are mandatory rules of law. This is the case in particular with the rules governing the termination of fixed-term contracts, the rules relating to the interview prior to dismissal, and the rules relating to working hours. Moreover, it has been ruled that since the rules of the application of collective agreements are set by legal and imperative standards designed to protect employees, the application of French law entails the application of the agreements that it makes compulsory. And those collective agreements are, like in Italy, very numerous, very complex and extensive. So as can be seen, even if it is legally possible to subject the employment contract to a law other than that of the place of performance, this practice is of limited interest given the importance of the rules recognized as mandatory in French law. So to make a quick conclusion, if it is obvious that the crisis has demonstrated that telework allows some people to work from anywhere. But this is not without upsetting all the existing legal, social, and even fiscal principles, which naturally have not envisaged this singular and unprecedented situation. And in France, for the moment, there is no plan of the government to produce a legislation concerning teleworkers and telework for a company abroad from France. So if the practices of telework were to become permanent, it would undoubtedly be necessary for the EU and the national authorities to take up the subject and give the transnational teleworker his own legal status in order to simplify this situation. In the meantime, for France, please always consult a French lawyer before setting up a telework from France. This is in order to avoid the disastrous consequences of a badly settled situation. In France, the consequences are pretty heavy and pretty costly. So please always ask a French lawyer before you set up a telework situation. I thank you for your attention, and please feel free to ask questions in the chat.
Maurice, thank you very much. One additional question, because we were discussing this right to disconnection, and as far as I remember, France was the first country with such a regulation. Yeah. Is this valid also in case of remote work, or there is some kind of specific regulation? Can you tell us a few words about this?
I can go into specifics because I don't know exactly all the contents of the legislation about this point, but I know that it is one of the most important points and mandatory provisions of the French law to observe. That is the working time, and the right to deconnection goes with the right to have a resting time. A pretty strict working time legislation that is 35 hours per week, and you cannot overstep those 35 hours. If you overstep them, there is a consequence for the employer, who has to pay overtime, and in some cases, if the overtime hasn't been paid or it wasn't fixed in the contract, so he will have to pay fines also. So okay. Therefore, it's a very important question that you are asking. If an employee is teleworking from France, he has a right to be disconnected after his working times. So yes.
Okay. Thank you very much for your explanation. Let's summarize. The first of all, I want to thank you very much for being with us during our journey through Europe. It was a fantastic journey. It shows us that we have some differences, but probably in prioritized issues, we are the same or very similar. The COVID has changed a lot, and I think that in many countries we have new regulation concerning remote work, and I can see that development of such a way of working has started 1.5 years ago, but probably we can't stop it. So, and what is also very interesting that people demand Europe to be one big remote work area. And I hope so that, in fact, probably we all lawyers agrees that that we need some kind of the European legislation concerning remote work, just to remove those barriers which are now very high, and as I said on the beginning, that we technologically it's very easy, but legally quite complicated. Some technical issues, because I was asking you to give your emails to send the presentation, and I thought that it will be few of them only. But I can see that almost everybody is interested in our presentation. That's good for us. Thank you very much. It means that we did some good work. I confirm what Viola wrote on the chat, that I will send to Viola all the presentation and all the contact details of every lawyer on our webinar. So you will get the link to the record, you will get all the presentation, and you will get the detailed contact details to every lawyer from our webinar. So you can ask additional questions or just stay in touch in case of some additional issues. And what I can say, I hope it was the first, but not last, meeting of our Schindhelm Network Lawyers Group. And I hope that we can share with you other topics, other legislation problems, especially in the area of labor law, because it is my professional specialization. But we will discuss future topics. We have some ideas for you, so we will just stay in touch with us. We will try to give you more information about Europe, just to use our Schindhelm network. Of course, I have to thank you. I have to thanks a lot for all lecturers. You were fantastic. You did great job. You gave us a lot of information. So maybe some of them wants to return to record, because it was huge number of information. But anyway, it was a fantastic time with all of you guys, and I hope we will meet soon. So thank you once again, and have a nice day.
Thank you for your attention. Should you have any further questions on today's topic, our experts will be happy to provide you with further information. You can find our contact details on our website schindhelm.com.